So St. Louis Circuit Attorney Kim Gardner, the Assistant Circuit Attorney Chris Hinckley, what they did is they charged Patricia McCloskey with a Class E felony because she had a firearm that they said it was a weapon readily capable of lethal use. That's what I meant, it was readily capable of lethal use, and it was because of that. That's the premise on which the Class E felony is based, right? Except McCloskey's pistol was entirely inoperable. And it was entirely inoperable due to the incorrect order in which the firing pin and the spring were assembled. Now, that was done purposefully because Mark and Patricia McCloskey had used this particular pistol as a prop in a previous case that they worked on in the courtroom. And in order to bring the pistol in the courtroom, they had to render it inoperable, and they never went back and rendered it operable after that case. So Patricia McCloskey was out there on her front lawn with a knowingly entirely inoperable handgun. So here's what Kim Gardner did. Her Assistant Circuit Attorney ordered the crime lab to field strip that pistol, and then they discovered the improper assembly. KSD Case 5 on your side had the document showing that the lab stated the firearm was reassembled properly, test fired, and functioned as designed. So they took an inoperable gun, made it operable, and then charged her with a Class C felony. Go to danalash.com. You can see the documents right for yourself. So here's what's interesting. They turned their firearm in through their attorney on July 11th. The sworn affidavit written by St. Louis Police Detective Curtis Bergdorf was 9 days after the couple turned in the pistol. Curtis Bergdorf did not mention this in the July 20th sworn affidavit. 9 days after, again, the pistol was turned in and they knew it had been inoperable. He did not mention the fact that both firearms were unloaded. He did not mention in this affidavit that no ammunition was in the house. He did not mention in this affidavit that her pistol was entirely inoperable, nor did he mention in his sworn affidavit that the mob had broken a private gate to trespass on private property, and nor were the numerous reported threats from the mob mentioned. The pistol was presented as an operable firearm, a, quote, readily accessible lethal weapon, which it was clearly not, so Kim Gardner could secure a Class E felony charge against Patricia McCloskey. And in fact, Gardner writes in her statement, she says that the facts that form this basis and information are belief that she said that they had this pistol, the defendant knowingly exhibited in the presence of one or more persons, a semi-automatic handgun, a weapon readily capable of lethal use. Now, two things I want you to remember here. First and foremost, as I said, and this is why I put this bit of information first, Attorney General says the Castle Doctrine makes this irrelevant. And this is when we just knew that they didn't have ammunition. The Castle Doctrine, and I've outlined it on the show before, is quite clear. The Castle Doctrine in Missouri is expansive. I don't care if they went into their house. Castle Doctrine in Missouri says property, meaning beyond your house. This was private property. The moment they broke that gate, it was not a peaceful protest. The moment they stepped on the other side of that gate, that was trespass. Then they wouldn't leave, and they were screaming threats. They were staying around long enough for a couple to stop eating their dinner on their patio, call 911, go inside while talking to 911 and getting their firearms and then coming out. That is how long the mob was standing outside of the house. Every single fulfillment for Castle Doctrine was there. If you're arguing to me that, oh, well, they just, you can't say Castle Doctrine simply stepping a foot on the property. First and foremost, that's not what this was, so shut up. Secondly, you're demonstrating an absolute total ignorance of the expanse of Missouri's Castle Doctrine because it extends, as I said, and I repeat myself at this point, beyond the house. It extends to all of your private property, including the sidewalk in front of their home, because Mark McCloskey put that in himself. That's separate from the issue of a Soros-funded, politically motivated circuit attorney who is now using cops in an era of national unrest to fabricate evidence to frame citizens with felony charges. Do you understand the severity of this? Are we or are we not having a national discussion right now about policing? Are we or are we not watching this crap happen in Democrat-controlled cities? How is this acceptable? You take an inoperable firearm, you render it operable, and then you base your felony charge on the operability.